After 3 months, if they're not making us a serious offer, the next step is that we file the lawsuit. That's what I was explaining before, the summons and complaint. We have to pay $210 to do that. It lays out all of our claims, and we file that with the court, and then it is personally, physically served on the defendant. After that happens, they have 30 days to put in an answer. Generally speaking, they always ask for more than 30 days, and we grant that to them because we want to have a good relationship with them. We want to be on good terms, and we want them to know that we're cooperating. So we give them an extra 30 days. So that's an extra month. After they serve us with an answer, they will also include in that a request for bill of particulars. Then that is a document that we produce that lays out all of our claims and details. It spells out the date, the time, the location of the accident or the malpractice. It spells out all of the details, your personal details, the last 4 digits of your social, your year of birth, certain things we do not disclose, but we include all of the medical records that substantiate all of your injuries. And that's really the most important part of the bill of particulars, is that we spell out all of your injuries. After we exchange that document, we file something called an RJI with the court, which stands for Request for Judicial Intervention. That costs $95. We pay the court for that, and we set up something called a preliminary conference. At the preliminary conference, which is at the courthouse, sometimes it's done virtually, we schedule depositions, any kind of document exchange, and then depending on how soon the other side can do the deposition is really what holds us back. We can do the deposition next week, but I have the staff to be able to do that, and I'm always, like I said, looking to move the cases along as quickly as possible. But generally speaking, the other side does not have either the interest or the staff to complete the deposition as quickly as we do, and they ask for a date 6 months from now to do the deposition, which is very frustrating. And then when it comes around the time to actually do the deposition, I have my staff schedule it, and they make an excuse saying that they can't do it, they don't have the staff, they're not ready, and it's very frustrating. If this happens to us more than twice, we make a motion to strike their answer. And that's a motion in court that says if you do not do this deposition by the next date that's scheduled, we ask the court to strike your answer, which is basically like saying dismiss your case. Unfortunately, this doesn't happen very often, but it does put them under the gun to get the deposition done. And I have a whole team of people that work on motions for me that get those things done and out the door, because we don't want to put up with making the case take a long time. Now, I also made a video about what a deposition is, and you need to watch that, but basically it's a question and answer session where the lawyer for the other side will ask you questions about how the accident happened, how the malpractice happened, how it's affected you. And this is the basis of the lawsuit. So whenever you have a deposition, I or one of my attorneys will very thoroughly prepare you for the questions that are going to be asked, and will be with you during the deposition to object to any inappropriate questions. So you're going to be in very good hands when it comes to preparing and being with you in the deposition.